We cannot, right? So we simply believe that yes, what is written in there, it's correct and we have to abide by that. Or same goes with Quran, same goes with Bible also, right? So these laws are very much, we simply believe that okay, these existed, okay? And unlike the analytical school is concerned, because that mentions law is something which is verifiable and which is observable in nature. Okay, so that is the basic difference when you talk about the natural law school and of course the Australian schools or positivist school is concerned. Okay, now with respect to this natural law, I have put 3 questions here. Okay, first is where does the law come from? When you talk about the natural law, okay, now can anyone tell me now based on these 3 parameters, divine revelation, then numerality based, nature based, where does the law comes from? Of course it's the 3 divisions only, right? That law comes from these 3 categories, divine revelation, nature based and morality based, right? Now how the law is binding at a particular time? वहाँ पे उस टाइम पे कोई सैंक्शन था कि आप नहीं मानोगे तो फिर there will be a punishment or fine or anything. Is there anything like that prevails? What is the binding effect? See, we know that law has a binding effect always, right? Natural law school mein what is that binding effect? Can anyone tell me? See, it is again with respect to God's will only. When you believe something because of your own conscience, ठीक है, then we, okay, for example, I believe suppose to slap someone is not good, right? That is my belief, that is my conscience, okay? Or for example, it is, suppose it's written that to, go to a path which is not represents the concept of dharma is wrong. That is a belief in the, which given in, for example, in Bhagavad Gita, okay? Now, if someone, for example, try to manipulate me and tell me that no, you do not go by this road, you go by that road, which is not, for example, ethical or which is unethical in nature. But I am, for example, ethical person, I will not do that. So that is my own conscience, and I derive that from the God's will, which is of course binding on me, because I pursue that existence and I believe that truth of that, the a priori method as I mentioned, right? And the sanctions, of course, sanctions is again divine sanctions. You can say that okay, the belief, for example, मैंने खराब काम किया, then of course मुझे स्वर्ग में नहीं मिलेगा जगह, मुझे नरक में जाना होगा. Kind of that conceptions, mythological belief. But हम में से किसी ने स्वर्ग या नरक देखा है? नहीं देखा, right? It's there only in mythological beliefs. So again, it comes only with respect to a priori method that we believe that something existed, and if I did certain wrong thing, I will be punished. Okay? Or for example, not after death also, but in my lifetime also, हम बोलते हैं ना कि हम जो खराब काम करते हैं उसकी सजा इसी लाइफ में मिलेगा. So that is again a belief system, how it works. So that is with respect to the sanctions that comes from natural law is concerned. Okay. Okay. Now with respect to morality तो हमने थोड़ा discuss किया. Now what law is? Anyone? Law क्या है? Law क्या है? हाँ? That is Austin's definition of law. And if I tell in the contemporary era, who is that sovereign authority? State. Okay. हाँ बताओ. कुछ बता रहे थे बेटा? Codified set of rules. Okay. Anyone else? As she correctly mentioned. Because in the contemporary era, who has the authority to make the law? Law बनाता कौन है? Legislature. And judiciary interpret करती है to deliver the justice, right? And executive to execute the law, right? So I can say that law is the rules It can be regulations which is codified in nature by the legislature in the contemporary era. Right? Now tell me, can there be any law which is morally wrong? Because here I will discuss the concept of law with morality is concerned. Now can anyone tell me, there are many laws in India, right? Can there be any one law which is morally not correct?
Preventive detention laws. Preventive detention laws.
Okay, preventive detention law bana क्यों?
That is again a very some sense they are morally wrong because there are certain provisions which violate right to life and liberty of freedom.
They were made for terrorist activity.
Cannot be actually say that it's against the right to life and personal liberty.
No.
See, yes.
They were made for preventing any future crimes like terrorism. Major
Right,
only done
right,
terrorism.
They were made for very extreme people.
Correct.
It's again very subjective. We
It's
have no
misused
science.
very often.
It's misused for sure.
Yeah, okay, okay.
However, again, this whole thing is very subjective because what may be moral for one might not be for the other. So, for example, even if we take, for example, personal laws,
Okay. Yeah, there are provisions like that. Now it's unconstitutional. But if I pose the question, is it morally correct? What are the grounds for triple talaq? कुछ grounds था, आप लोगों ने personal law तो इस बार पढ़ रहे हो ना? ट्रिपल तलाक का कोई स्पेसिफिक ग्राउंड था? कोई मेथड? Just pronounce the word and divorce. Talaq happened, right? So when I say, for example, if it is when the case is pending before the court, there are many petitions filed, right? Muslim women, men organizations say, women organizations say. What are the issues in triple talaq case? Is there only one issue? एक ही issue था? ट्रिपल तलाक के बाद कौन सा एक्ट आया?
Protection of Muslim women.
Right. इसमें section, if I am not wrong, section 3 में that is criminalized. Right? Okay. Now tell me one thing. If you anyone read the full judgment of triple talaq? पढ़े हो? No. You have SSC online access, right? So you can read. See, what are the issues specifically I am talking about? One is of course triple talaq. The remaining two issues.
Question regarding maintenance.
Maintenance is Shah Banu's case. Sorry, Shah Banu's case. It's a movie. I think it's released already, or it's yet to release. It's released. Okay, do watch that movie. It's Shah Banu's case. Okay. Second is nikah halala. Okay. Now what nikah halala is? And the next is polygamy. What about polygamy and nikah halala? Are they morally correct? Itwari versus Ashgari का केस पढ़े हो? Itwari versus Ashgari on the concept of polygamy. See, simple है. Supreme Court ने इस केस में specific बोला है that if anyone wish to marry a second time, that particular husband have to see both the wives equally, love the wife equally, respect the wife equally. Is it possible humanly? And if I love the first wife, why you would marry a second wife? Right? If you interpret in that way. Okay. And what is nikah halala? Muslim personal law है इस बार आप लोगों का? No, next semester. For example, there is a woman, there is a man, B. Both are Muslims. Now she got divorced or talaq from her first husband, and now after the talaq is granted, again they wanted to marry each other. In Christian law, Parsi law, Hindu law, there is no such specifically concept of nikah halala that prevails under Muslim law, because in Muslim law what the wife have to do is, if she wishes to again remarry her first wife, she have to marry again with another man, consummate the marriage, and then have the divorce from that husband, perform the iddat period, and then she is again capable to marry her first wife. So what is her, where is her right to privacy or her bodily autonomy is concerned? Right? See, these are the things we write good articles also, because these are the domain where the interpretation is very important with respect to law and morality is concerned. Okay. So yes. So when you talk about now relationship between law and morality, see, it's always go hand in hand. Okay. In the contemporary era, for example, when I say that what morality is and what law is, morality is something which the legislature have to look into while making a new law or amend a particular law or repeal a particular law is concerned. Okay, because what is not accepted by the society, suppose, can this law can be implemented? First question is that, because the legislature make the law for the people in the society. If the people are not ready to accept that law, is there any relevance to of that particular law? See, in India we have many such laws. For example, Dowry Prohibition Act 1961 में pass हुआ, right? Is it fully executed till date? Dowry आज भी मिलता है, देते भी है. Child marriage भी होती है. Child marriage is I think last time मैंने बताया था 1929 is the first enactment. So see, there are many such things which we need to look into with respect to when you talk about the concept of law and morality is concerned, and specifically the relationship is concerned. Okay. Now, I have divided the relationship between law and morality into 3 categories. Okay, which you again need to understand. First is moral as the basis of law. Now, what is that? When you talk about moral as the basis of law, it means that see. Generally, when you talk about the law, it's laws made by the legislature, which is based on certain moral principles. Okay, and origin of law is mainly based on the moral principles when you talk about natural law is concerned. Okay, and throughout historical perspective, when you look into, there is no specific distinction which is made between law and morality. And that is, you can say, one of the most significant reason that the laws found their origin from what was considered moralic conduct by the people in the society. And eventually, the legislature pick up some of those moral conceptions or customary practices which prevailed in the society and make them law. For example, in personal law, when you talk about, for example, the concept of saptapadi is concerned. Okay. These are some of the practices which are earlier prevailed as a custom in the society, and afterwards these are made as a law under the Hindu Marriage Act, right? Or for example, when I say that before, suppose DNS is enacted or IPC is enacted, is it permissible to kill someone or to harm someone? The answer is no, right? Because that is morally incorrect. These are universally applicable, the rules of natural law. Now, I hope you know the rules of natural law, principles of natural law. That is, you can divide it into again only order of partum, right? Here both the sides. And then, of course, rule against bias is there. So, these things are very much inherent in every legal system around the world. It's not something which is, only applicable to India, right? So these are the things which you can say that these are a basis where law can establish its rules. Now, second is morals as the test of law. Now, when I talk about morality as a test of law, that some of the jurists believe that there should be no contradiction between the law and morality. Now, one of such jurists is of course Fuller. Right? Now, what Fuller believes is law and morality are, you can say that, or in other way, if I say that Fuller believes that without morality, law cannot exist. It's based on the moral principles, right? Now, any law which is contrary to the moral principles should be removed according to Fuller is concerned. Now, in other sense, if I say that morals as a test of law is, now what is you already say that you already read contract law, right? Now contract law में क्या होता है? Agreement बनता है, right? Suppose one of the components अगर मैं बोलूँ, now suppose one party deal with his or her part of the contract, the other party is not performing that. Okay? Now what remedy that other party has, or what law can do there? What is the objective of law there? Or in any law, for example, चोर theft हुआ, डकैती हुआ, okay, or murder हुआ. Now why we seek the remedy from the law? Law क्या करता है? What law delivers? Justice, right? So when you talk about the concept of justice specifically, now you can say the entire purpose of law is to deliver justice to those people who actually suffered something, or something wrong has been happened to him or her, or a group of people, suppose, right? Now, or for example, I can say law is something which is for the welfare of the people. Okay? So since the principle of justice is well under the ambit of the morality, many jurists believe that there must not be any contradiction between the law and morality, and any law which does not abide by the moral principles or standards should be removed, and the law needs to be always valued in terms of moral values and principles of natural justice, or more correctly if I say the principles based on justice, equality and good conscience, right? Now based on these three, the court decides a particular case. So we can say that where the law is establishing or enacting any particular legislature, when enacting a particular law, of course it take into consideration the moral principles, and even in absence of a particular law, okay, the court look into the principles of morality which are based on the concept of good conscience and equality is concerned, right? So that's how you can say that morals are the test of law. Okay, it's along with the law also, and when the law has certain limitations or there is no specific law is concerned, there also you can say that the law can just deliver justice with respect to or based on specifically moral principles are concerned. Okay, these two are clear. Okay, the last point is morals as the ends of law. Now what does it mean? Ends of law मतलब क्या? Anyone wish to try? See, again, ends of law and test of law is something similar in nature. Because when you talk about morals as an end of law, now end of law means of course always to deliver the justice. Okay? Now the purpose of morality of course is to remove the conflict from the society. Okay? And its means, objectives of morality and laws are almost, you can say, the same. Now, as I say, based on moral principles, it is also correct to say that yes, there should not be any conflict in the society, and law is also tries to of course maintain the law and order in the society, right? So, as an end of laws, morals as the end of laws, you can say that the purpose of both the phenomena is the same, and it is believed that by the jurists that if the law is to stay involved in the lives of the people, then it cannot ignore the moral principles also. If there is a law against the moral standards, it may happen that people will hesitate to obey, and it will create a further conflicts within the society. So that's how you can say that yes, there is a close relationship between when you talk about law as the ends of morals as the ends of law. Okay. Now moving further, based on this conceptions of law and morality is concerned, we'll start with respect to H.L.A. Hart and Fuller. Okay. Who is H.L.A. Hart? बेटा बात मत करो. Hart कौन था? The theory of H.L.A. Hart with respect to what law is.
Law as it is.
Law as a
Is as it is.
नहीं समझी.
whatever the law is, you just follow it.
Okay, little interpretation of law.
Can't be subjective.
Can't be subjective, okay. For example, I'm talking about section 5, clause 1, subclause A of the Hindu Marriage Act, rule of monogamy, right? It mentions in the black letters of law that when the marriage is solemnized, either of the parties should not have a leading spouse. If I interpreted it, law as it is, then of course it means that person should be, unmarried at a particular period of time when he or she is actually getting married, or do not have any leading spouse, right? Or literal rule bhi wahi bolega, right? But when you talk about, for example, law as it is, there are other dimensions that I take the example from one of the legislature which is there in India, which is codified already. That means HLA talk about the laws which already existed. We can interpret the law what is existed. If the law is not existed, then there is a simple difference between law, what law is, and what law ought to be. Right? What law ought to be belongs to which school? Law क्या होना चाहिए और law क्या है? हाँ? Natural law school. So what law ought to be is always based on the natural law principles. Needs to be made by the legislature, or you can say it always includes the universal principles of law. But when you talk about HLA's conception of law, it is with respect to what law is. Even in doctrinal studies, specifically doctrinal research methodology, it always emphasizes with respect to Austin's conception. Because doctrinal method में researchers only read the law, analyze the law and interpret the law as law is, as the text of the law is, right? So that is what HLA has mentions with respect to law is between law and morality, but they are not interdependent. That is the main and major conception of what is concerned. In some of his texts, Hart mentions that okay, there is maybe a relation when you talk about between what is law, what is morality. But according to him, that is not interdependent of each other. कि ऐसा होगा तो ऐसा होना है. Okay? It is Hart belief that law has been heavily influenced by the morals, but there needs to be a strict distinction between what law should be and what law is specifically. Okay? And secondly, when you talk about Fuller's conception, Fuller belongs to natural law school, or you can say he is a naturalist who believe that there exists a strong necessary connection between law and morals, and according to him, all legal norms are based on the conception of moral norms is concerned. Okay? In simplest terms, the Fuller believes that no law can be deemed as valid if it is not past the test of morality. Okay? Now again, these two jurists specifically debated with respect to what law is and what morality is. Okay? With respect to analysis of law and Fuller's debate, see, when you talk about both the philosophers, that is Hurt and Fuller is concerned, it aims to achieving the justice, but their way of achieving the particular justice is different. Okay? Let's see, for example, when I say there is a law, suppose, that to prohibit, okay, of parking of certain vehicle in a public park, suppose. Now, when you talk about with respect to morality is concerned, for example, parking my vehicle to any of the places, is it morally wrong? Morally wrong हो सकता है क्या? That what will be the answer? See, morally when I talk about, I can park the vehicle at a place which is may not be used by frequently, because then the passers-by will be, creating, there will be a problem. But when I keep my vehicle, for example, besides the road, okay, then is it morally incorrect? But there is a law saying that no vehicles can be parked here, no parking area. Morally, वहाँ पे तो कोई जा भी नहीं रहा है इससे पार्क ही नहीं, like for example segregated place from the roadside. See, morally, when you talk about it, may happens that it's not incorrect to say that okay, you can park your vehicle in a roadside. But why it's legally wrong? To prohibit maybe the accidents. Okay, that is why it's termed as a no parking area or no parking zone, right? So there can be many instances which talks about these kinds of examples. Or suppose I will give one known example, the Nazi resides. Okay, ये तो आप लोगों को पता होगा क्या हुआ था? Nazi's incidents was good or bad?
Inhuman.
Inhuman. Okay. क्या हुआ था? बताओ.
Jews were
नहीं समझी.
the Jewish
Yeah,
people were
genocide, yeah. और कोई बताएगा? Okay, in this class, how many of you believe that what Nazi government did was correct? Please raise your hands. Anyone? Anyone in the class who believes that what Nazi government did is correct? Please raise your hands if anyone believes that. What happened? तो बिलीव करते हो ठीक था नहीं यू कैन देयर इज नो हार्म इन दैट नो ओके देन आंसर मी व्हाई नॉट क्यों गलत था ही हैज दिस राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन अंडर आर्टिकल 19(1) प्लीज
Ma'am, it was against moral principles that people were killed because of their race and ethnicity.
ओके बताओ You can answer me, right? No need to discuss. बताओ बताओ. तीनों तो बात कर रहे थे. Okay. Anyone else? See, main thing is with respect to what she correctly mentioned, that it's very inhuman in nature, and you can say it's totally the law is against the moral principles. You cannot kill anyone based on their race, ethnicity, religion, caste, creed. Even Article 15 and 16 now, it's restricted, prohibited. Okay, you cannot discriminate anyone on the basis of these things, right? So now, why it is so? आप लोगों ने Constitution पढ़ लिया?
it's going on this
It's going on. ये Article 15, 16 हो गई, 14 हो गया. Okay, Constitutional Assembly debates पर है. क्यों आया राइट टू इक्वालिटी देन आर्टिकल 15 क्यों आया व्हाई इट इज प्रोहिबिटेड ऑन द बेसिस ऑफ कास्ट क्लास सेक्स रिलीजन प्लेस ऑफ बर्थ व्हाई रीजन क्या था सी व्हेन यू टॉक अबाउट कॉन्स्टिट्यूशन या फिर आर्टिकल 17 स्पेसिफिकली राइट अनटचेबिलिटी ये प्रोविजन आया क्यों
how society was because it prevailed for a very long time in Indian society.
yes
It was more
See, the main thing is, when you read the, please see again, you are a law student. When you are reading Constitution, please read the Constitutional Assembly debates. I know it will take consume certain time from you, but please read. Because then only you can have the broader picture कि why certain law is specifically enacted. Or suppose with respect to that Sabrimala's case, that morality and constitutional morality, right? Gender equality or gender inequality or क्या? Constitutional values is concerned. सबरीमाला का केस तो सबको पता है, right? Now I can guarantee that every one of us will support that judgment कि हाँ सबरीमाला में अच्छा हुआ, but is it executed? Execute हुआ है decision. What do you think? This year I visited Kerala. I really want to visit that temple. My driver told me I cannot go. So where is the justice prevail? He mentioned that when your husband can go, you cannot enter it. This is a Supreme Court ruling, and we all are from law background. There is a divorce happened just because she entered into that temple from Kerala only. The husband gave divorce to his wife on the ground of cruelty, and the court accepted that. So where is justice prevailing in this society? See, simple है. आप लोग सारे law students हैं, second year है अभी 3 years और है. Whenever you think a particular conception of law, always think critically कि why. Being a student of law, you always have to have that answer कि why any law is made or enacted in a particular way, or why a particular law is amended, why a particular law is repealed. Okay, because then only you can have an intellectual mind and you can actually interpret the law beyond the literal interpretation. Because then only you can actually understand that when purpose of interpretation or mischief rule of interpretation needs to be applied in a particular given situation. Because literal rule is very easy, and specifically the fiscal law is concerned, penal law is concerned, it's only the literal rule can be applicable. But for example, certain laws which are given to give benefit to a particular group of people, suppose Maternity Benefit Act, Consumer Protection Act, Workmen's Compensation Act, right? Now these laws are made to give compensation or certain benefit to a particular group of people, right? Now there, or for example, in a case of the Debnath versus Railway Board Authority, in that case what happened? There is one Bangladeshi woman who was gang raped in India. IPC applicable है बांग्लादेशी women पर, foreign nationals पर.
Yes, the crime took place on the soil of it.
Jurisdiction क्या है IPC का? Every law has its jurisdiction. IPC का jurisdiction क्या था? Or please read that case. Because see, now what Supreme Court did is, in this case, we have international law or international conventions. India is a signatory to CEDAW, right? Conventions on the elimination of all forms of discrimination against women, right? Now in that particular case, or that Tripura versus Railway Authority Board, in that case the Supreme Court actually taken consideration of the CEDAW articles, okay, and remedy that particular woman. She received compensation. Now suppose if the Supreme Court provided error interpretation or only followed literal rule of interpretation, she do not have any remedy per se. But that's why you need to have certain international conventions, treaties in hand to discuss sometime or to deliver justice in a particular point of time, because it's always not it's always not possible to deliver justice only by applying the or municipal law is concerned specifically when these kinds of situations is applied. Rather than even if, for example, the Indian law is concerned, that also, for example, certain child rights is concerned with respect to Prohibition of Child Marriage Act, which I discussed in DSNLU class. We have CRC also, Conventions of the Rights of the Child. There are also many provisions are there with respect to protection of the rights of the children is concerned, right? So these are the things which you need to incorporate when you talk about the concept of law and morality is concerned. Now the 8 principles of legality. Okay, I will start from here. It's 11:15. I will start from 11:30. I will complete the 8 principles, then relate Stephens, and then I will discuss the other. Okay. So I will go there now. I will come at 11:30. Okay. Thank you. Contract law, consumer protection law, Maternity Benefit Act, or whatever law is BNSS, BSA, BNS, every law is very much clear when it comes to its application or what that particular essentials are of a particular crime. It's there, right? So that's how According to Fuller, he mentions that the laws need to be like that. Reason being, if the law is ambiguous in nature, it is not possible to apply the law justly or in a fair manner, right? So that's how the Fuller mentions that laws should be clear and intelligible in nature, okay? Then there should be no contradiction between the laws. Of course, for example, one law is saying, ki, okay, the marriageable age is, for example, 18 and 21. Okay. Now the other law, for example, says that no, it is 18 for both the parties. Can the legislature enact such laws? The answer is always no. Reason being, if the legislature is enacting the laws which is conflicting in nature, then of course which law will follow, which law will prevail? Or for example, constitution, I think you didn't read it yet. Oh, it's going on, right? If any law, suppose, or for example, can any law passed by the legislature which is violative of fundamental right? No, right? See, simple hai. The part 3 of the constitution is protecting the rights of the individuals, and these are the negative rights is concerned. Because the state has the responsibility to protect that rights of yours, okay? And any law which is not made in consonance with the rights of the people, the fundamental rights of the people, of course, it needs to be stopped, right? So, any, or in other words, if I say any law which is ambiguous, okay, or for example, any law which conflict with another statutory law is concerned, not for example constitution, but any other statutory law only, then also it is not possible, because that will be conflicting situation then in the society, that which law will override the another one, or which law will prevail in a particular situation. Then it should be constant. Now constant means, of course, if the law is randomly changing, or for example repealed, amended by the legislature, then people will be confused, or there will be no clarity among the laws, that what laws need to be applicable in what situation. So it should be very much constant. See, कोई भी law जब pass होता है, it takes many times. Yeah, I hope the procedure, how the law is made, you know. It's a lengthy procedure, right? So once a law is made, the legislature makes sure that the intention of the legislature is very clear, and it should be constant in nature. It should not be randomly changed, and that is why the purpose of interpretation and mischief interpretation are there, to broaden the ambit in certain manner until it is permissible by the legislature, legislative intent is concerned. Okay, so that should be constant. There must be possibility to obey the law, of course. Now, for example, the legislature enact the law randomly, whatever it is. For example, वैसा कोई law बना दिया that which cannot be accepted in a particular society, or which is not possible to accept by the society or the people of the society. So that kind of law cannot be made by the legislature. So any law which is made by the legislature, it needs to be a possible chances that people will follow that particular law. And last is, law should be administered in a way that should not diverge from its obvious and apparent meaning. That is with respect to your literal rule of interpretation. That whatever the meaning of the law is, it should be very much clear, and it should be administered in a particular way. Doctrine of necessity, as you correctly mentioned, okay, can be applicable to save like individual's life by killing someone else. Doctrine of necessity, right? पार्कर को मारा गया था, right? डुडले एंड स्टीफनसन ने मिलकर मारा था. Okay. Now when you read the fact of the case, now apply the principles of law and morality there. First of all, let's discuss this case with respect to the principle of morality. There were 4 people, right, in this particular boat. Now Parker is the cabin boy, or is the most weak one, who is actually killed, and the 3 people, by eating his flesh and blood, he survived for some more days, and of course ultimately they were rescued. Now while applying the principle of morality, is it correct to do so? Or doctrine of necessity, what in how much time, like doctor, the defense of necessity, if anyone is taking to protecting his or her life, justifying the, of course, killing someone else. Moral principles क्या बोलते हैं? You read this particular judgment. What is the moral arguments based on morality? The justification of moral principle saying that it is morally correct to do so, to save his or her own life. Correct? But when you talk about legal principles, there were cannibalism के लिए punish हुआ था, right? Now when you talk about legal principles or law is concerned, the judiciary in this particular case mentions that you cannot take the defense of necessity for killing someone else and to protect your own life. It is not permitted, and Stevenson and Ridley were charged for murder of Mr. Parker, and they were actually found to be guilty under this particular case. So that is, it is one of the renowned case again you can say where the concept of law and morality, is applicable by the jurist, and beautifully applicable, I would rather say, to establish the fact that when moral principles need to be, limited with respect to its application, and when the law needs to be prevailed in a particular situation, right? Because as I in my starting lecture today say that all moral things cannot be justifiable in the parameter of law is concerned, right? So you have to have that knowledge regarding the factual metrics of the case, what the fact talks about, okay? And of course, based on that factual metrics, the judiciary have to execute that particular law in hand, okay? So that is with respect to hard and fuller debate. Now this is again one of the interesting topic which I think you people didn't learn it. Okay, tell me, you know about the pro-life and pro-choice conception? Anyone, or is totally a new conception for you? Like, why I'm asking is, should I need to start from the scratch that what pro-life and pro-choice is, and then come to law and morality, or you know the basic understanding of what law, pro-life and pro-choice is? You know. Anyone else? What is pro-life and pro-choice? कुछ आइडिया है? pro-life क्या है? X versus principal secretary पढ़े हो? X versus principal secretary, Supreme Court की case है 2022. Okay, let me start. Pro-life conception. What is pro-life? It's regarding the abortion debate I am talking about. Okay, pro-life simply means you have to protect the life of the fetus. That means when you talk about the law of abortion, it is not permitted under the conception of pro-life. Okay, simply in a layman language if I say. And when you talk about pro-choice conception on the other hand, it gives the bodily autonomy of the women and gives the rights to the women that when she wishes to procreate a child, okay, and if she is not ready, it gives the right to the women to abort that fetus. That is the pro-choice, that is the choice of the women. Okay, in a nutshell if I say, the basic conceptions of pro-life and pro-choice. Now we'll connect it with the conceptions of law and morality, of course. Now when you talk about pro-life conception, see, as I mentioned in previous classes also, whatever law we have in India, it's based on certain moral principles, right, which possesses certain moral principles based on which the legislature enacts the law. You are from this class? Okay, come. That particular law, particular assumptions that we mentioned that, what is right or what is wrong or what are principles also mentioned that morality as a constituent factor for determining the validity of the law, right? Now the moral proposition of the scriptures include the sanctity of human life and affirm the values attached with freedom and human right. Now again, when I look into the concept of morality, then you will understand that if there is a conception of Aristotle also in natural law school, the principle of potentiality or potentiality principle. That principle believes that or mentions that the fetus and the embryo should not be massacred or killed as they possesses all the attributes of human life. Now natural law school में आप लोग division करे होंगे medieval era, Catholic Church वगैरह, right? Now there is a conception from the medieval era also that the Catholic Church specifically considered killing the fetus as a sin. Okay, so these are the things which supported the conceptions of pro-life. Pro-life specifically believes that when the fetus is, we need to understand the first case, which is Roe versus Wade, and of course which is overturned now. Now Roe versus Wade case, you know, okay, this is a very famous case when you talk about the law of abortion is concerned. It is not an Indian case, it is a US Supreme Court case. Okay, now in Roe versus Wade, the Texas laws criminalized abortion and it was considered as a murder. Okay, now what happened in this case is this order was challenged, okay, by the Roe in the US Supreme Court, where all the pregnant women who formed one class filed a petition before the court, and the issue before the court is whether or not the constitution recognizes women's right to terminate the pregnancy by abortion. That is the main issue before the US Supreme Court. Now further, they also included the 14th Amendment of the US Constitution, citing that liberty is inherent with respect to the women's rights is concerned. Okay, and it also mentioned that pro-choice discourse mentioned that women have the authority to decide whether their bodies should be used for the purposes of procreation. So that is, these are, you can say, these are the significant issues which is attached with this particular case of Roe versus Wade is concerned. Now what the court mentioned in this case is that liberty is a very much part of the 14th Amendment of the US Constitution, and it is protected by the 14th Amendment of the US Constitution. So in this case, the court basically ruled that Texas state law was unconstitutional and is prohibited the law of abortion except for saving the life of the mother. So Texas का जो law था वो आपके कोर्ट US Supreme Court ने prohibit के unconstitutional declare किया, and it कोर्ट ने ये भी बोला as it is on the ground that as it is prohibited to the law of abortion except for saving the life of the mother. Now in this case there are other nuances also, that it's mentioned or you can say it divided the pregnancy period in 3 trimesters specifically, where the court mentions category wise that when state has a role to play with respect to protection of the life of the fetus, and when it is only the mother who has the right to abort the fetus. The court very beautifully in this case narrated that in the first trimester, okay, it is only the mother or the woman who has the absolute right, okay, to abort the fetus.